Good day. Today, I'm really looking forward to the interview that we've got. We've got Alan Nelson, SC, lined up, and he's going to talk to us about litigation versus mediation, how they differ. Now, this is such an important topic at the moment because the concept of mediation has been introduced into the Uniform Rules of Court in terms of Rule 41A recently, and there are a lot of people that are grappling with, well, when we have to consider mediation, what do we have to think about? What is this concept of mediation? Is it just a couple of people getting together and sitting around the table and trying to come up with a solution, almost a form of negotiation? Or is it something more than that? Is it more structured? Is it more professional? Does it fit within a particular context? And Alan is going to take us through that, and you'll see he's a great speaker on the topic, and I'm really looking forward to this. Alan, welcome.
Thank you, Ian. Good to be with you.
Great to see you again, Alan. We're recording this in the middle of the coronavirus lockdown. It'll be available on YouTube after the lockdown, but it's actually nice to see friendly faces in these times. So there's that angle to it as well. Okay, Alan, I think I see that you prepared a slide presentation. If you want to just take us straight into that slide presentation, and let's hear what you've got to say about litigation versus mediation.
I think, yeah, Ian, let's start with what litigation and mediation have in common. And I think to introduce this topic, we've got to look at what conflict is, because both litigation and mediation are mechanisms to address conflict. We talk about conflict resolution mechanisms, and they call mediation one of the alternate dispute or conflict resolution mechanisms. I believe it should be the mainstream mechanism, and that's certainly going to happen now with the amendment to the rules that you've mentioned. But litigation and mediation both have as their purpose a mechanism to resolve conflict. Now let's look at a definition of what conflict is, and the Cambridge English Dictionary defines conflict as an active disagreement between people with opposing opinions or principles. And that's a pretty fundamental definition of conflict that I think speaks to the problem that both litigation and mediation seek to address. We all know that when people are in a conflict scenario, it's very difficult for them to speak to one another, and it often is almost impossible for them to resolve the conflict themselves. And that is where litigation and mediation and also arbitration come in. And we have had these mechanisms that have evolved in order to try and assist people to resolve conflicts, litigation being one of them, and then mediation and dialogue being another. So both of these mechanisms for the resolution of conflict have in mind to achieve an outcome to disputes and conflict that is morally right and fair and in accordance with the law, which is really the definition of justice. So I think that kind of sets the tone for where we're going, because both of these systems that have evolved over time are designed then to try and achieve outcomes to disputes and conflict that is morally right and fair and in accordance with the law. That is, however, almost where the similarity between these mechanisms for the resolution of conflict end. And I think to just go further with this, what I'll do is I'll take you through a definition of litigation, a definition then of mediation, and then of the different kinds of mediation, because there's a lot of misunderstanding out there with regard to mediation. It actually means a lot of different things. And when we deal with mediation, and especially with the new High Court rule, we need to know what kind of mediation is being spoken about. So if I can start firstly with a definition of litigation, and Ian, here I'm going to pause after I've read the definition so that we can chat a little bit about this process, which both you and I have spent a lifetime dealing with. Yeah. So litigation is defined as being a process where public officials, I don't want to make out that judges are not very important people, but at the end of the day, they are public officials, and they're appointed by the state and paid by the state, and they decide cases by applying the law to their understanding of the facts, after which they proclaim who is right and who is wrong. Litigation is a process which is adversarial, it is adjudicative, and it's publicity prone. So Ian, maybe you can come in here and I think tell the listeners a little bit about what this litigation process actually entails practically in terms
Yes,
of time and how it works.
absolutely. And remember that we talk, I mean, you're talking broadly about mediation. The whole focal point of the website is medical law and ethics. So we deal a lot with the impact which disputes and conflict have on the medical profession, on the healthcare systems, on the patients, that type of dispute. And what we find there is that you have professionals who are very often trying to do their level best in difficult circumstances, who might make a mistake, or just because of the system itself, something goes wrong, and then they find themselves in this litigation model, and that has been the default mechanism for dealing with disputes in South Africa up to now. And the problem with that, from the particular perspective of healthcare practitioners, is that it's absolutely devastating to that healthcare practitioner's motivation, to their reputation. And the features of litigation that particularly add to that is that it's lengthy, it's draining, it's as you've said, it's adversarial. In other words, it's just almost like escalates the conflict, because now the parties can't talk to each other. So there's that cycle of escalation, Alan, that you taught me about in my mediation training. That now is that elevates. Adjudicative means now that there's somebody else who's deciding your fate. There's a judge who will decide whether you were right or wrong, negligent or not. And so it's an intensely destructive process. So in summary, that's the litigation process from the healthcare practitioner's perspective. From the patient's perspective, it's frustrating. It's lengthy. It's incredibly expensive. So the stakes are very high. You've then got patients who often have a legitimate grievance or feel they've got a legitimate grievance, and and all these parties get sucked into a system where, look, sometimes you have to litigate, but very often there's a better way, there's a more constructive way and a more intelligent way of dealing with that dispute. So that, in summary, is litigation from that perspective, Alan.
Ian, I just want to come in here on one point and perhaps emphasize it, because it's something that lawyers often don't realize, and that is that when parties are subjected to litigation, it is massively invasive on their dignity. And when I talk about dignity, I talk about your ability to enjoy life. And I've had this experience myself in having been sued and also having litigated against others in my personal capacity. And even though I had exceptionally good cases in all of those matters, the trauma and the stress that I went through during the time that litigation was pending was incredible. When you're dealing with medical doctors, of course, you're dealing with people that, that are being challenged so far as their professional ability is concerned. And it's being suggested that they've acted contrary to the standard of care expected of people in their position. That's an enormous accusation to face. Whether you're guilty or innocent doesn't make any difference at all. The trauma that you suffer during the years that it takes for those matters to be resolved in a court of law are massively invasive and cause huge harm to the medical practitioners. And we mustn't also, as far as that is concerned, discount the effect that the uncertainty and time have on the patients themselves and their ability to enjoy their lives. So whilst we litigate in medico-legal disputes, and solutions are not found yet, during all that time, both the medical practitioner and the doctor suffer enormously and go through incredible invasions of their dignity. And that, unfortunately, is one of the things that litigation does. I apologize.
Yeah, no problem at all. No, absolutely, Adam. All right, let's have a look at your next slide.
Good. So let's look at the definition of mediation. Firstly, I think the point to emphasize is that mediation is a process. So it's not like you're sitting in a court of law. It's a process that can actually take place anywhere. And at the moment, we're also talking about doing this process even online. And there will be a discussion later, I believe, about that topic. But it's a process where disputants engage an independent and impartial third party that assists them to resolve a dispute and or conflict. So a few things I want to stress here is that the disputants must engage this person. So it's a voluntary process where the disputants decide who the person is that they want to use to assist them to resolve a dispute and or conflict. That person has got to be independent and impartial. In other words, he mustn't take sides at all or even be seen to be taking sides. And what he really does is he assists the parties. It's kind of nothing more and nothing less than assisted negotiations. It does take different forms, and I'll be dealing with that in a moment, but it's really nothing more and nothing less than a third party, an independent person coming in and assisting parties to resolve their dispute. It's a confidential process, and it's consensual. Confidential, by confidential, I mean that nobody knows about what happens at a mediation. It's completely off the record. It's also without prejudice, which means that it can't prejudice any of the parties if the matter is not resolved in the mediation and for some reason or another, litigation or arbitration must continue. So it's a very, very effective way of giving parties space in which to try and find a solution to the conflict themselves. And the important thing to stress here, it's not adversarial, it's not adjudicative, but it is consensual. In other words, the parties are trying to find an agreement to the dispute themselves. And if I can go back now, Ian, for a second, just to the definition of justice, there is no better way of achieving a just outcome than by allowing parties themselves to try to find a solution to their conflict in terms of an agreement, i.e. consensually. And it's based also on what the parties' needs, interests, and concerns are. But I'll come back to that in a moment.
Absolutely, Alan, and you know that's where we see that at the end of the litigation process, you know, after 5 years, 7 years, 8 years, and enormous amounts of money and disruption, as you say, quite rightly, to people's lives, often very serious disruption. What one finds at the end of that process is that even the winning party is not entirely satisfied. So you wonder whether that process was actually worth it in the long run. Whereas in a mediated approach, if we can get to a solution where both parties feel that their needs have been met, even if not fully, but a lot better, then that's a far more constructive way to deal with conflict, and can also lead to actually a building of the relationships between those people instead of destroying those relationships.
Absolutely, absolutely. What litigation does, Ian, is it looks back. It looks at the facts as they occurred at a particular point in time. In fact, a reconstruction of those facts, which we all know is never entirely accurate. It is based on memories and people's ability to recall what happened or what didn't happen. It's always fallible, but it looks backwards and it decides who's right and who's wrong based on what happened in the past. Mediation doesn't do that. It focuses more on the future. And it, with reference to what parties' needs are, what their interests are, and what their concerns are, looks at what they really want going forward and couches or assists parties to couch solutions based on looking forward. In other words, what do I really want now, given what's happened to me in my life, looking forward, and how can I find a solution to that as soon as I possibly can? So I'm not saying that who's wrong and who's right is completely irrelevant, because obviously one of the concerns that a disputant would have is, well, if I do take this matter to court, what are my prospects of success? And based on those concerns, he will set his standards in relation to what he wants or she wants going forward. But this is the fundamental difference. And I think in medico-legal matters, it's really important, because when we mediate medico-legal matters, we look at what the patient really wants and really needs going forward and how those needs can be met. And we also look for what we call high-value, low-cost solutions, where it could cost party A very little, and he could produce a massively beneficial outcome or advantage for the other party, given the circumstance in which that party finds himself. This is very often happens in medico-legal mediations, in my experience.
Very much so, and I agree.
So I'd like us, if you don't mind, I know it's a little bit technical, but to look at the different forms of mediation, because there is a lot of confusion out there, especially amongst our legal colleagues, Ian, because of the fact that mediation has carried so many different meanings over time. And I'd just like to kind of categorize them for our colleagues and for interested people. so that when we talk about mediation in terms of Rule 41A, we all know what kind of mediation we are talking about, because
No, absolutely, and I think that'll be very, very helpful, and just clear up a bit of confusion that seems to be out there, and that's exactly the sort of information I think a viewer would be interested in. Let's go for it, Alan.
Yeah. Okay. So firstly, we've got 4 different forms of mediation. Some of them overlap a little, and others don't. But the one form of mediation that has been very prevalent in the construction industry, civil engineering industry in South Africa, especially for many, many years now, ever since I started practicing law 40 years ago, is what they call adjudicative mediation. So this is not mediation in its true form at all, and yet it is called mediation. If you look at civil engineering contracts, you'll see the word mediation mentioned all over the show. It's adjudicative mediation. I'll come back to that in a moment. Then there is evaluative mediation, and then facilitative mediation and transformative mediation. And here there's a lot of overlap between facilitative mediation and transformative mediation. So there really are 3 different categories of mediation: adjudicative, evaluative, and then facilitative and transformative. So if we look at the definition of adjudicative mediation, it's a process, again, where disputants engage an independent and impartial third party that assists them to resolve conflict. In this form of mediation, the mediator forms a view on who is wrong and who is right. So the only consensual element is that the parties can decide if they accept or reject the mediator's decision, but it is a decision. Sometimes that decision is, okay, let's split the difference, but he makes a decision. Now, lawyers, including myself, that have encountered this form of mediation have found it to be disastrous in many instances, because as lawyers, we know if you want to decide who's right and who's wrong, then you have no choice but to go a process that is similar to litigation, i.e. where there is full discovery of documents, where those documents are analyzed by leading witnesses and having those witnesses cross-examined by extensive expert evidence to help the judge understand the technical aspects of the case, and then by detailed argument in relation to what the law is and who is right and who is wrong according to the law. And as lawyers, we know that there is no way in this world that a person, often these people are not even trained lawyers, just sit there, hear the parties. Lawyers many times don't participate in those kind of mediations, and then decide who's right and who's wrong. And for us as lawyers, this form of mediation is an absolute no-no. And that's why a lot of attorneys and a lot of advocates, if clients ask them, should we mediate this dispute, they will say to the clients, don't do it, because we know that you can't trust a process like this to give you a fair outcome, an outcome that is just, that is morally right and fair and in accordance with the law. 99% of these cases, they're not according to the law at all. And they certainly are not morally right and fair. So a lot of the resistance to mediation that I've encountered over the years has been because when you talk mediation, lawyers think back of this old form of mediation, which is adjudicative in its style. And I would agree absolutely with them that this is not a form of mediation that can produce just outcomes at all in conflict scenarios. So I want to take you then to the next form of mediation, which is called evaluative mediation, which is similar to adjudicative mediation, but not entirely the same. Here again, we're dealing with a process where disputants engage an independent and impartial third party that assists them to resolve a dispute, but it's assisted negotiations where the mediator gives advice and or influences the parties regarding legal liability. For me, this is a particularly dangerous form of mediation because once again, as a lawyer, I have seen so often, as you have, I'm sure, Ian, in cases where you run the case, all the experts are on your side and everything is fantastic. And then all of a sudden a new fact emerges and that fact changes the outcome of the case in its entirety, one way or the other. So for a mediator to evaluate and to start to tell parties who's right or who's wrong or who he thinks is going to win or who's not going to win if the matter goes to court is an extremely dangerous and unacceptable form of mediation, in my opinion. And I would not underwrite this mechanism for the resolution of disputes at all. Because what happens is because you sit as a mediator, the parties tend to trust you. Well, certainly if you're a good mediator, they will trust you. And so if you push them in a direction, they'll follow you. Yeah. And you're pushing people in a direction knowing that a detailed and thorough investigation of the facts and the law has not taken place, there's been no legal argument, there's been no proper legal evaluation of the scenario, and yet you're telling people what the outcome is or isn't going to be. And I find that that's a particularly dangerous form of mediation, and I would certainly not advise anybody to engage in this kind of mediation. So let me take you...
Just before we move off this one, because this now, and you may want to double back to this, but let me just put this issue on the table and then you can deal with it. Because again, from the clinical negligence perspective, particularly where you've got expert witnesses who obviously now by definition, unless you're co-mediating, in which case it may be different, but very often even that, there are different fields between healthcare practitioners. Now, the question I have for you is, where you have that factor, I'd like you to address the question of if you're not going to engage in evaluative mediation, and maybe now when you move on to the facilitative mediation, you can deal with this. How do you deal with the type of issue where it's very helpful to know what the facts are? It's helpful to know whether the medical practitioner has complied with the standards of his or her profession, and one actually does need that sort of insight in order to be able to facilitate an outcome. So I think maybe just bear that in mind, and you can either deal with it now or you can deal with it when you move on to facilitative mediation.
I think, Ian, this is a good opportunity to deal with that. Remember that I said that mediation looks forward and tries to find the best possible solution based on the needs, interests, and concerns of the parties. Now, a concern that a medical practitioner has to take into account, as well as a patient, in deciding what solution is acceptable going forward or what solution to agree to going forward, is most certainly the concern, what will happen if this matter goes to court? And it's a form of reality checking that we often use in medico-legal mediations and in others too, where we will say to parties, if they are hesitant to come to a conclusion, have you applied your mind to what could happen here if this mediation doesn't produce a satisfactory outcome that both parties accept and the matter goes to court? And it's in that context that the issue of liability or otherwise arises. Now, for the mediator then to tell parties what he thinks is going to happen without a thorough investigation is really dangerous. So what we advise in those instances is that the parties, in collaboration with the mediator, refer the files and the documents and all the information to an independent expert. And that expert preferably should be one person or organization agreed to by the parties. Now, we know that the Society for Obstetricians and Gynecologists have set up expert panels that they will appoint that will provide guidance in relation to issues of liability. And they will do it as an independent entity. They will accept liability if they are wrong. In other words, if they give bad advice, they can be sued, and they accept that they have insurance to cover them in that event. And they will then give feedback to the mediator and the parties to say, look, in these circumstances, we believe there was or wasn't negligence on the part of the medical practitioners for the following reasons. Then the parties, based on that information, can take decisions going forward. They, of course, can consult their own experts should they wish to. But the benefit here is that we have an expert or panel of experts that are completely independent and that then assist the parties in order to take informed decisions going forward in regard to this concern. Am I liable or am I not liable? And it's not the mediator who is giving this advice. The problem if the mediator gives this advice, and one of the most important things for a mediator to do is to earn the trust of the parties. They've got to trust you. They've got to really believe you're working super hard to help them find a solution. And both parties must trust you. Because if they trust you, they're going to disclose things to you that they haven't perhaps even admitted to themselves, pertaining to issues of liability and their needs, interests, and concerns. And the moment I start to tell a doctor, look, I think you're negligent, I think you acted improperly, that person's not going to trust me if he believes otherwise. Or if I tell a patient, I don't think you've got a case, that I'm going to lose the patient's trust. And so a mediator really acts in a manner that is very harmful to his need to be independent and impartial and to earn trust of the parties if he starts to tell them what to do. And the use of these independent experts is absolutely the way to go. And Ian, as I understand it, and I'm really happy to hear this, that your website is going to at some stage give people guidance as to who they can perhaps approach in terms of an independent expert to assist them on matters of liability. And that's not necessarily only medical experts. I believe that should also cover legal experts as well. So parties should be able to know, we can go to Mr. X, he's the top guy on this particular topic in relation to medico-legal liability, and we can ask him to give us input. And because both parties are approaching him jointly, he doesn't take sides. And you and I both know that despite the fact that experts all tell us that they are not biased, once we appoint them to act for us in court cases, well, there are very few of them that don't end up agreeing with our client's case when the matter is argued. And this is one of the major problems in medico-legal litigation at the moment, because you have so many experts giving evidence, and as the judges have commented on often in the past, is it just a coincidence that the batch of experts appointed by person A have an argument that strongly favors that person and opinions that strongly favors that person, and the opposite applies to the opposing party? And I mean, in some of these cases, as you know, we've had as many as 54 experts appointed on both sides. And that's what's made, sorry.
Yeah, sorry, not to interrupt your flow there, but I just wanted to say that this question of experts now, obviously within the clinical negligence sphere, is absolutely crucial. And it's crucial in litigation, and it is going to be crucial in mediation as well. And getting the right expert is always the key to unlocking a clinical negligence dispute. And we know that as practitioners, you know. And it gets to the point where actually there's a particular expert in a particular field. And as practitioners who do this, we know whichever party gets that expert, I tell you what, that party, if you get into court, you've got serious problems against that party. They're in a very strong position. Now, wouldn't it be far more appropriate to get that expert appointed as a joint expert? You both parties trust, he's known that, or she's known that reputation precedes them. You know, this person says that this is the situation. You're not bound by it, but practically speaking, you've got an authoritative voice trusted by both sides, and it almost just clears that issue up. Of course, you can go and get a second opinion if you want to, or you can disagree, or you can try and persuade the expert to change their point of view. The process is dynamic. But isn't that a far more appropriate way to implement? And Alan, you know, one of the things that I do look at, and I'll do some work on this in my website, but if you look at the regulatory provisions regarding the expert evidence, probably the key principle that comes out time and time again in this country and around the world is the crucial nature of expert independence. They have to be independent. And when you're in a litigation process, it becomes so difficult also from the expert's perspective, because they've only heard one side of the story. They've only seen one, you know, and so when you put them and you jointly appoint an expert, it really helps to get full value from that expert, in my view.
Ian, I've had experience of this myself in mediation matters, and I can promise you it is unbelievably beneficial and successful, because the expert's he doesn't take a side. He really just looks at the documents and he gives objective advice to both of the parties as to how he sees things going forward. And it really is incredibly valuable and useful, and saves an enormous amount of time and massive costs. I mean, you can just imagine in terms of how much money it saves the parties if they can get one opinion together that deals with issues of liability. But, you know, the other thing I want to stress is that we must be very careful to overemphasize issues of liability as well, because often when you start to look at what people really want and what they really need, and the ability of the other side to address those needs and those interests and those concerns, liability very often kind of wanes into the background, because what's happening now is what I really want is being taken care of. And if I'm a patient and an operation has gone wrong and I'm in pain and I'm suffering, what do I want more than anything else in the world? Is I want that problem to be overcome as soon as possible. And if I'm incapacitated or not able to work, or whatever the case may be, that I be fairly compensated for that as soon as possible. I mean, if we look at cerebral palsy matters, we know that the opportunity to improve the child's life after a cerebral palsy incident is maximum of 7 years. What do we want for that child? What do the parents want for that child? They want the problems to be addressed to the greatest extent that they possibly can as soon as possible within that 7-year period. And what happens now with litigation is it only gets addressed after the 7 years are over, and we can do nothing for the child to improve the child's life.
And
Whereas within the
it's a
7-year
great
period, we
example.
could have done it.
Yeah, no, it's a great example. Okay, Alan, let's move now onto adjudicative mediation. Let's have a look at that.
I know facilitative. So we go to facilitative
sorry.
mediation, and this terminology, guys, I want to don't run from it, because actually this is true mediation in the real sense of the word. Again, it fits the general definition of mediation because it's a process where disputants engage an independent and impartial third party that assists them to resolve conflict. The definition of facilitative mediation is that it's assisted negotiations where the mediator does not give any advice or steer the parties in any way regarding liability. All that the mediator does here is he facilitates a conversation, facilitates a discussion, controls a process between parties that are in conflict or in dispute to help those parties find the solution themselves as to what best meets their needs, interests, and their concerns going forward. So when we talk mediation, this is actually what we should be talking about, facilitative mediation and nothing else, where there's no adjudicative, no persuasion, no pushing people to come to a particular decision. You simply facilitate a process, and then, as we've stressed already, Ian, part of that facilitative process is, where necessary, help parties to find an independent expert that they can both appoint or approach to assist them in relation to medico-legal issues, or whatever the case may be, if that becomes essential. But here, the facilitative mediator simply assists the parties during negotiations and helps them by setting some ground rules and controlling the process and helping them through what is obviously a very difficult time for both parties in medico-legal matters, very difficult time because of the trauma that they're going through. And so this mediator, for example, creates an environment where parties can, without prejudice, speak openly to one another, tell them exactly what happened, why things went wrong if they did go wrong, tender genuine and honest apologies, even accepting liability in circumstances where that's justified, looking at one another across the table and talking to one another. And that process then gets facilitated by this mediator. And there are a lot of things that he can do to ensure that that process will be beneficial to both parties. So, for example, although the mediation is voluntary, a good mediator in a facilitative process will keep parties at the negotiating table until they've explored all of the possible options, all of the possible solutions that could bring about a satisfactory solution, and then assist them to evaluate those options and assist them then to pick the option that is best for both of them, due regard being had to what they really want and need and what their concerns are going forward. So this is mediation in its true form. Allied to it is what we call transformative mediation, and it's very similar to facilitative mediation. It's assisted negotiations, again, where the mediator places emphasis on transformation and development. So what the mediator does in transformative mediation is he really tries very hard to place both of the parties in dispute in a better position to the one in which they were before the conflict arose. I want to try and give that a medico-legal connotation, if I may. Let's say, for example, a problem arises in a state hospital and an operation goes wrong, and the matter is mediated within weeks of the problem arising. And during the course of the mediation, the parties that were responsible for the difficulty sit across the table and talk to one another about what went wrong. And they're honest and they're open and they're apologizing where necessary or explaining what happened where necessary. I've so often, Ian, heard patients say, all I want out of this is this must never happen to anybody else again. And of course, now we can take this mediation process. We can identify what went wrong, and we can ensure that that problem is in fact taken care of, and that the same kind of thing doesn't happen to anybody else in future. And so we transform a scenario where perhaps things were going wrong at this hospital quite frequently on the same level for the same reasons. We take that and we transform it into a scenario where the problem, the genuine problem, the deep lying problem in that hospital is dealt with, is addressed. And so we transform the scenario in which both parties find themselves. And so facilitative mediation and transformative mediation are much of the same thing, because facilitative mediation almost always has a transformative effect. And as mediators in the facilitated mediation process, we always try our very best to help parties find a solution that will place both of them in a better scenario than they were before the problem arose.
And Alan, if we just go back to an earlier point that you made, and if we now just sort of zoom out in our minds and think difference between mediation and litigation, through litigation, you will never get to that point of transformation. You'll get an imposed solution, narrow. So you've got a narrow cause of action. You've got a narrow set of relief that you're entitled to. But there will be no, unless the matter's settled. But even then, you're not going to get this type of innovative thinking, this dynamic thinking, creative solution, problem-solving approach to the issue. And that, to my mind, and particularly within clinical negligence, but more broadly even than that, to my mind, that is one of the strongest features of mediation as opposed to litigation, is that you can come up with these creative solutions, and actually, if you think about it, you can actually dig deeper into what the underlying cause of this problem was in the first place.
Yep.
And that, to me, is phenomenally powerful.
Yeah, and if you do it relatively soon after the incident, and you've also got this huge advantage. The facts are fresh and they're real. They're not conjured up after the event based on consultations with lawyers and trying to fill in gaps and cover holes, etc. It's based on what actually happened. And a good mediator that earns the trust of the parties will help people to uncover those facts. And, often when I'm in conflict or in dispute, I never admit that I'm wrong. But a good mediator taking me through the event quietly, slowly, helping me to see what I don't see, if I've been wrong, will help me to realize that I've been wrong and admit the shortcoming. And then, of course, going forward, I won't do the same thing again. I'm not going to make the same mistake. And I've had a matter where it was a person's computer mechanism. It was a computer program that fed incorrect information after an operative procedure was followed. But for the mediation, the mediator, the surgeon wouldn't have realized that, there's a problem with how this thing feeds information back to him and it's got to be addressed. And so that program was rewritten so that in future the same problem wouldn't arise in similar circumstances. So, this is a huge benefit of mediation that often is lost sight of. It's not often the benefit of mediation, not just for the parties themselves, but it has huge benefits for people outside of the mediation that could be faced with similar difficulties going forward.
Yeah. All right. So as we start heading towards a close here, Alan, do you want to just give us some...
Yeah, let's try and summarize. Yeah, I'd love to talk to you further about the ability of litigation versus mediation to achieve just outcomes, but maybe we can talk about that in another session at some later stage, because I firmly believe, in having litigated for 40 years and mediated for 10, that mediation is far more able to achieve just outcomes than litigation is.
And so I think what we must do is let's make that a topic on its own, and we can deal specifically with that aspect, because I think it's so important, and it's something that I think let's rather deal with it on its own, and we can do it fairly soon. So people watching this particular video can then follow up with that, and I'll liaise with you, and let's deal with that topic as well, Alan, because that is crucial. Yeah.
Okay. So let's just summarize quickly the differences. I've got this chart up, hopefully that all of you can see, but those of you that can only hear, when we talk litigation, arbitration is very similar. The only differences being that you appoint your judge and you pay for him if you arbitrate. So it's actually more expensive, and it's a private process, but it's similar to litigation. So in both litigation and arbitration, we've got an outcome imposed by a third party, whereas in mediation, we've got an outcome determined by the parties themselves. So litigation is adversarial. The outcome is imposed on parties. I heard you use that word, Ian, quite correctly. It's an imposed solution or answer based on past facts and the application of the law to those facts. In the case of mediation, we're looking at a consensual process, i.e. one that's by agreement. It's an outcome agreed to by the parties. It's based on their needs, interests, and concerns looking forward. In the case of litigation and arbitration, only one party can win. In the case of mediation, the parties try to achieve win-win solutions. And I need to stress here that if you look at those benefits that I spoke of earlier, you very often find those win-win solutions that place both parties in a better position. Litigation and arbitration destroys people and their relationships. Conflict continues sometimes for generations. And I mean, we look at doctor-patient relationships where people were close, like family, A problem arises, one of them sues the other, that doctor and that patient never talk to one another again. And often it's remembered generations later because of the suffering that either the patient and or the doctor went through while litigation was on the go. Mediation, on the other hand, restores dignity and relationships. It resolves conflict by transforming it into positive outcomes. Then litigation and arbitration, the courts have limited powers. Mostly monetary relief can be granted. Court can't go and tell people to redo operations and to do this and to haul in that expert to do this procedure or do that, or whatever the case may be. So the courts have limited powers. Mostly monetary relief is granted. In the case of mediation, unlimited solutions are possible, including ones with a high value for party A and at a low cost for party B. I want to talk about that in another session, Ian. There's not time today, but I've got some beautiful examples from mediations that I've done where we look at these high value, low cost solutions that are really and truly amazing, almost unbelievable. But as I say, time limits us from doing that.
Yeah.
Then litigation and arbitration is time consuming and extremely expensive. It can take many years and cost millions. I mean, the most recent Supreme Court of Appeal matter, medico-legal matter, took 10 years. And the court overturned the decision of the lower courts. And you can just imagine the trauma that the doctors and the patients have gone through during all this time whilst these matters have been decided. Mediation is relatively inexpensive. And when I say relatively inexpensive, Ian, we've done some calculations. You're looking at the cost of an average mediation in a medico-legal matter costing 0.02% of what litigation would cost. 0.02%. And it can save millions in costs and damages, and it can mostly be over in a day or two. So 90% of matters that are mediated, international statistics show, are successful. 70% of that don't last longer than 1 day. And in litigation, we know that medico-legal matters, because they are complex and difficult and problematic, take many, many days to resolve in a court of law and to take an extremely long period of time. And then, of course, you also know that you don't recover all your costs, even if you win a litigated matter. So you end up paying in order to get a judgment in your favor, and that cost could cost you up to between 40 and 60% of the costs that have to be paid for the case. So those are essentially the main differences, Ian. And yeah, I don't know if there's still time for me to deal with. Is there anything you'd like to chat to me about in those?
No, I think that, Alan, I think that sums it up nicely, and I think we've taken it to a point where we've given a good, thorough understanding now of the different types of mediation. I think there's a clear understanding of the differences between mediation and litigation, and I think what we must do, and instead of sort of cramming some important information in now, let's do a separate interview, and let's go through those issues that you've raised. And we can and then do sort of almost a part 2 to this interview, and then let's explore in detail some of those things. I think that's going to be far more effective, Alan. So I just wanted to do any remarks in closing, Alan.
Just in closing, Ian, I think, and I know you've had talks on this, and I'm sure there'll be many going forward. The new Rule 41A, if you look at the definition of that, clearly talks about facilitative mediation. It talks about a mediation where the mediator facilitates discussions between the parties and assists them in their negotiations to resolve the dispute. Very important. So we are talking about a facilitative process. What is also important to highlight here is that the definition of mediation in Rule 41A doesn't only deal with a resolution of the matter in its entirety. We all know, all of us mediators know, that often where you can't resolve the matter in its entirety, you can then break it down into parts, and you can see whether and to what extent the parties can reach consensus on the different elements of the case. And in that way, even if the matter does eventually have to go to court or go to an expert for a determination, you can ensure that those issues are confined to the least possible ones in the circumstances. And so the High Court rule is going to make a huge difference to the way all disputes are dealt with. And I think personally that there'll be very few where it can honestly be argued that we can't mediate this matter, because if we are talking about assisted negotiations, you and I both know that there's not a single case almost that goes to court where there can't be negotiations between the parties to see whether they can't find a solution either to the whole matter or to elements of it. So this is going to make a huge difference, and I really think that legal practitioners will be well advised to learn more about mediation. And we are going to have very short courses on the fundamental aspects of mediation once a month on the first Saturday of every month. If anybody wants to join me, we'll have webinars, and you'll be very welcome to log in if you want to find out more about mediation.
I think that's a fantastic initiative, Alan. And what I will do from my side is we'll make sure the Practitioner's Guide keeps up with you guys. And so when we do that directory of practitioners, what we'll do is we'll make sure if they attend that sort of course with you, that can go up on their little bio sketch, and then that obviously can be something which people can then identify who the appropriate legal practitioners and their appropriate experts and mediators would be in those circumstances. All right, yeah. Alan, thank you very much. This has been very, very interesting. I'm sure the viewers will get a lot from this. There definitely must be follow-up interviews on this as well. And we'll do a webinar with you soon as well, Alan. So I'll keep people posted on that, and get information about upcoming events that you'll participate in. Alan, thank you so much for your time. Great seeing you. Great seeing you during the lockdown, hey? Nice to visit with you.
Absolutely. Good to see you too.
Good, lovely. Cheers, bye. Cheers, bye-bye. Bye.